what he paid for. But this person is thinking an effort, is thinking a business, is creativity a business. Think of an artist just drawing some of the wall. That is a preoccupation, that's his occupation. That's how he makes his money. That's how you want to buy his car, buy his house, take care of his family. Therefore, we give him, he has the right to whatever comes from the creation of his mind. And what therefore is intellectual property? I will say it in the simplest way, is creations of the mind. Simplest. There are many ways you can look at it. You can read the World Intellectual Property Organization. They have ways of defining, but the simplest way is creations of the mind. And the person who has the creation, the person who creates intellectual property has rights to it. So these creations of mind can be like a product in your business environment, products that you have, or even parts of the product. You can have a whole product, let's say a phone. If you pick a phone itself is intellectual property in many aspects. And within it, there are also IPs, a lot of them, the software that's running it, the components, the design of that phone, and many things are there. So it's the product and parts of it. How about the name? If it's Nokia, if it is Samsung, those are actually intellectual property. They could be trademarks, okay? The name, the logos, even the slogans that go with them, because they actually identify the products with the creator of that particular product. The processes or methods of processing, that's also intellectual property. There are many ways, for example, that you can be able to make, think of a pot. You can go and get some clay, knead, do all those things, and end up with one pot or two or three. But you can also be able to come up with so many pots out of automation. You have a machine that can make pots. How does the machine make the pots? How does it even do the kilning and all that within maybe an hour or less? That's a process, is a creative process and can be actually protected as intellectual property. Sounds, literary artistic works that you see every day. I gave you example like what you may have on your advertisement, the copy, the computer programs, databases, all those things are intellectual property. The creative aspects or the creations of your mind. I will give you a good example. Think of an organization or a company that manufactures yogurt. And you see that actually intellectual property is actually the business. It's nothing, it's not peripheral. That's the main business. If you get it out of the equation, they don't have a business. Because if this company that manufactures yogurt has a process through which they do fermentation, they add these, they have some formulas, all that, that process of making the yogurt is patentable. It's actually patentable. You can patent so that nobody else can use that process without your consent or without an agreement with you if you patent it. The process. The yogurt, the outcome of the process, is also patentable. The content, that yogurt is patentable. It could be having a different taste, different chemical formula on all that. That is patentable. So contents of the yogurt, that's the product, and processing methods are patentable. So that's actually IP. Alternative to patenting is what we call industrial or trade secrets. If you look at patenting as a situation where you let out the formula, you give it out in public in exchange of legal protection. That means out there, everybody knows that this formula or this machine or this process is a property of Mr. X, where X is you. Therefore, I cannot use it unless I get consent from him. And the law protects that. Alternatively, you can say, I'm not giving out the formula. I'm not showing our processes, but I want to keep them under lock and key safely, that even the people can access the organization are just through a system that has been well designed so that the information is not out there, the formula is not out there. Then you are keeping that as an industrial or trade secret. I'll talk more about that at some point. Now, the process and the product itself are patentable and can still be kept as industrial secrets. On that container, that has the yogurt. You have a name, Chobani. That name, in marketing, you'll call it the brand name. It has a logo, it has maybe a slogan or something like that. It is a trademark. It's a mark that distinguishes your product from other people's products, or basically identifies your product with you. I may mention that commonly you see some places where the brand names have an R in a circle, and some have TM. Someone may want to know why TM, why R, and why not put, anything else. TM basically stands for trademark. R is registered trademark. They have legal implications. You can't use R in a circle if it is not registered. It's an offense. But TM may mean that you intend to trademark it. In some circles, we shall say it's totally meaningless because it does not guarantee any protection the way trademark registered R will be able to guarantee. So this name, the logo, sometimes the color, even the scent that identify your product can be trademarked. That means registered as trademarks. Now, you'll be talking about Greek yogurt, non-fat, blah, blah, and make some stories around it, even develop some adverts out of that. The advert that you make, the copy, what you call copy in marketing, is actually copyrightable. There's something interesting about copyrights. Unlike trademark, industrial design, and patents, the creator of copyrights assumes protection as soon as they create them. They don't really have to register them in many, many jurisdictions. But it is good to register them because the certificate of registration will be very useful when it comes to a dispute. It's an evidence of ownership. It's very cheap, by the way, to do the copyright registration. So your website, your database, or list of customers, any literary work, the music that use all that are actually copyrightable. But how about the shape of this container? That shape can be unique. And maybe if you look at the shape of Coca-Cola bottle, if you look at the shape of many others, you can still be able to protect those shapes as industrial designs. And when we do that, that means nobody else can be able to use those shapes without your consent. So basically what you're seeing here is that everything you do, from the time you get in the office, you're already dealing with some intellectual property. The only question is it yours, nobody's, or somebody else's? Nobody does not apply. As long as it's created, it belongs to you or somebody else's. If it belongs to you, is it protected? It belongs to somebody else, is it protected, and you have a consent to use it? Because potentially that's a risk. It's a risk handling somebody else's IP without consent. Okay, you don't know when it's going to explode on you, but if it does, you may find yourself in the situation of Salt Bay and many other people. So basically, elements of IP in your work environments. Business name is also an IP. And someone may want to ask me that we already have a registered company name. Do I still have to register it as a trademark? I'll advise to do so. Because registration of trademarks is a rigorous process that gives you exclusive rights to use that particular mark. So you can actually, by the way, register brand name or even your company name. And so many companies have done that. I think, and I should give example, try to mess up with the name Safaricom somewhere, you see what will happen to you. Okay. Brand name, logo, slogan, product identity can also be, those are IPs. Your processes, your product, your services, website, business cards, literary or product literature, videos, illustrations, any music you use are all IP. You can't avoid it. You're either using your own or you're using somebody else's IP on a daily basis. I'll just talk about each of these elements of IP, how IPs are protected. They're protected in forms of trademarks, patents, copyrights, industrial designs, trade secrets, among others. And I'll begin with a trademark. What is a trademark? We say it is a sign capable of distinguishing goods or services of one enterprise from another. And I may just want to explain that it's not just a sign, not just a logo. It's not just, it can be a name, it can be color, it can be scent, it can be shape. Whatever you use to distinguish your product, or a combination of all this. It can be 3D or 2D. But the role is that it's used to distinguish your products from, to show that it belongs to one enterprise and not the other. So that if anybody else comes with the same logo and color and shape, we can be able to ask him that this, does it belong to you? Do you have any evidence? Do you have any show of ownership of this? We usually say, when you're doing your branding, don't spend money on what does not belong to you. The surest way for ownership of that name, of that logo, is by registering trademark. I've just given some examples of definitions of trademark and brand. Probably you can see that a brand and a trademark sound the same in terms of definitions. I've just taken authorities, WIPO, World Intellectual Property Organization, and America Marketing Association. When WIPO says a trademark is a sign capable of distinguishing goods or services of one enterprise from those of other enterprises. Then when you come to AMA, they talk about a brand as a name, term, sign, symbol, design, or combination of them. You see, basically, if you're a manager in marketing, you are looking at the same thing, basically. Only that you can go ahead and do the branding and make sure you are well known and make sure that your brand has a lot of value, or what you call a brand equity is well, you know. But then if you don't protect it, what happens? Suppose someone else comes and registers that mark before you do it. In America, trademark is given to the first person to use, even if registered. In Kenya and many jurisdictions, many territories, trademark is given the first person to register. So the first person to register has high chances of winning a trademark dispute where both parties are claiming the trademark. How long does trademark protection protect that name or the mark? Perpetually. When you do your trademark registration, it takes about 5 to 7 months to do registration of trademark. It's quite a rigorous process, and like registration of company name and all that, because it gives you monopoly to that particular mark. But then after 10 years, then you have to do renewal, and you can renew like forever. Probably I may mention that there's some marks that also are akin to trademark called geographical indications and certification marks. That's all very essential, and that's a part of IP. And a good example is usually champagne. You can't come up with a product there and say, claim it's champagne. Champagne actually attaches that product to where it's been made. I think it should be somewhere in France, a place called Champagne, because it's believed that wine from that particular place, because of some geographical uniqueness, tastes different. And therefore, that's why the geographical indications attach to that particular product. If you do otherwise and call your product champagne today, other than infringing the rights of the champagne makers, you'll also be it will be a bad business practice in the sense that you'll be lying to your customers. Okay, of course, you can end up diluting the name champagne in the process. And certification marks are the ones that show some quality. Recently, there's a group of women in Kenya who have come up with a certification mark for their products. I think they're doing baskets and exporting. Maybe if I remember, I'll share with my slides, that particular group, showing that this mark, when it's on your product, it means it has better quality than the rest because it has gone through some rigorous process. These are part of what we call intellectual property, and these are marks that your corporation or your company can be able to take advantage of. Then we have the copyright, which protects original works of authorship, or sometimes call them literary and artistic works. That's music, that is a passage, or just computer software, by the way, also belongs to copyrights. architectural plan, those are copyrightable. So the authorships, literary and artistic works are protected as copyrights. Copyrights basically are creation in your lifetime plus 50 years after you're dead. So as long as you live, lifetime plus 50 years, you're copyright protected. Are you together? There are other rights that are close to copyright called related rights. That when you have your music copyrighted, there are people called performers, they have their rights. Those actors, singers, and musicians. We have producers of phonograms, sound recordings, they have their rights also. And broadcasting should have their rights to the same product. So they're usually called, we shall talk about copyright and related rights. You may want to think of Jerusalem, when all companies were seeing Jerusalem everywhere. As much as it could have been very expensive probably to do litigation and claim on the performance and copyrights of that globally, but be sure that there was exposure. By you just standing out there and sing Jerusalem, that's somebody's product. And I think you know the song called what? The Lion Sleeps Tonight. In the jungle, the mighty jungle, that song. You know the story about, you can Google and find out. These are very serious copyright issues. And as a commercial break, I'll just show you one which is very interesting. This one here. Listen to this carefully.
You know Shakira was sued because of this song? Waka Waka was selected by FIFA as the official anthem for the 2010 World Cup. Listeners in Cameroon, Africa thought that the tune sounded a bit familiar. The song sounds a lot like Zangalewa by the Golden Sounds. The song became such an instant hit in Africa that Golden Sounds actually ended up changing their group name to Zangalewa. But regardless of the original song's popularity, Shakira never got permission from Golden Sounds to make her own rendition of the song. She actually claimed that she came up with the song herself on a walk home one day. But as you can hear, the song's choruses are exactly the same until the very end. After online campaigns put tons of pressure on her, Shakira, her label, and Golden Sounds reached a settlement out of court.
Wonderful. Resettlement out of court. You know, when you're doing a business, you may not think about it. It's easy to get one of your employees coming up with a better way of, seeing the process of marketing your product, but they're infringing somebody else's copyright, and that can cost you dearly. Actually, there's an element of copyright in the country now in Kenya, where I think both the supervisor, not the employee, the supervisor and the corporation are liable of copyright infringement within the course of duty. What that means is that if I work for company X and there's a copyright infringement in the course of duty, then the company is liable, and myself as the boss of the person who infringed the copyright, I'm also liable. Be careful of such kind of they're there. Be careful of this kind. You have to know this because it can actually really mess you up. So you think about this song of Waka Waka and Shakira, assuming that was your employee who did that. You know, everyone's been enjoying, sounds good and all that. Along the way, you realize that now you have to pay. You're in court. You need to know what these things are and what you call IP and how to deal with them. So as I said, it's either yours or it belongs to somebody else's. One of the most misconstrued form of protection of IP is a patent. Is a limited duration protection that can be used to protect inventions, I wish I bolded that, or discoveries that are new, non-obvious, and useful, such as processes, machines, articles, composition of matter, and all that. When you're doing patent protection, 3 things are looked at. One is called novelty. Another one is called inventive step. And the other one is called industrial application. Of course, a fourth one is not precluded from registration as patent by the national laws. So what it means, you can't patent everything. And these are very sensitive area if you're doing research, R&D, because the moment you launch that product, you cannot patent it anymore. Novelty is gone. It's dedicated like that. It has to be novel. That means it's not in the public domain in any way. Inventive step means that it's not obvious to a person skilled in the art. It's not something like adding blue to yellow gives you green. It has to be something that you spend some effort. It's not easy to guess. And of course, can be applied industrially. That's why you cannot be able to probably patent, what do you call it? You can't patent a mathematical formula because it may not be industrially applicable. Now, if you look at these patents and this form of protection of patents, remember we talk about trade secrets. In many literature, you'll understand that trade secrets and patents go hand in hand, in the sense that you're making a choice of letting the formula, or you're making a choice of letting your invention, the process, for the public to know, so that you can be given exclusive rights to use it. We have to know that. Why I said patents are commonly misconstrued, you cannot patent your name. Managers, don't say that my name is patented. You cannot patent your name. I will not answer any question when someone will ask me that, is Kiondo patented? I think by the end of this, you should know whether Kiondo can be patented or not. Yes, you can't patent your name. Reason being, remember we talk about novelty, inventive step, and industrial application. And of course, there are other laws that not preclude what you cannot be able to patent. So some people think of copyrights as the thing, I've copyrighted. You can't copyright certain things. The things can't copyright. There are things you can patent, but you can't copyright. And things you can copyright but not patent. I don't know whether that's clear. If it's literary, artistic works, that is not patenting, that is copywriting. If it is an invention of a process, a product, all that, that is patenting. That should be very clear. So don't, from here, we should not be confusing them. And trademark is very useful. And what I really get surprised about is that as useful and as simple as it is, we still don't understand what it is. We still think that trademark is actually a business name or just the same as branding. So those are things we need to think of. Then trade secrets, I just mentioned these are private information that's important to business because it gives you a competitive advantage in the marketplace, but you've opted not to protect them as a patent. You opted not to register them. We opted to keep them secret. If you do it well, it can take like forever. Remember that Coca-Cola formula has been protected as a trade secret for how long? More than 100 years. How they do it is a discussion of another day, but you can't do that. The problem with trade secrets and patent is that the options they're choosing. Remember, when your trademark is out there, your trade secret out there, it stops being a trade secret. So you have to choose, are you able to keep it a trade secret? Do you have strategies? Do you have systems? Do you have ways of keeping it a trade secret? I think I've been seeing things about a trade secret of Coca-Cola, the formula, and someone says even the people who know it at any given time, there are only two, they can't travel together. I don't know who knows it and who knows it, because remember, we have what's called corporate espionage. Some people can even come and get employed there to see what's happening. So you have to be very careful to deal with it, but when you do it well, it still works as a trade secret. Before I go to this, I wanted to mention something else, that while IP is basically about patents, copyrights, and trademarks, I've still demonstrated that, copyrights, patents, trademarks, and trade secrets, There are other aspects of the same IP protection that go beyond, or let me say is like fall under the same protection. For example, we have what you call industrial design. Industrial design basically is a form of a patent, by the way. Industrial design is a form of a patent. And we have what you call utility models, also a form of a patent. And we have so many others. I just look at this from a compacted view, given the time that we have as we are speaking now. This is what's happened in Africa. And we decided to just take data of trademarks, applications, class counts by origin in 2018. Africa has only 2.4% of trademarks in this category. And you can see the picture. If you see the map very well, it shows you that where we have 1 million to 9 million trademarks counts per class. I'll talk about what that means. You can see that some areas are darker than others. Look at Africa. In fact, we have even gray, no data in these places, I think because of their IP offices may not be having data or may not be established. So we need to up our game because Africa, there's so many brands. There are so many brands in Africa as we're speaking. How come they're not trademarked? Does that expose us to competition in a way that we are likely to lose? And of course, in our practice, we also noted that many corporations from outside, particularly India, we've seen a lot of Indian firms coming to trademark in Kenya. Before they start, they come and trademark first. Before they even, the first thing they do is they trademark, now they can be able to start a business in Kenya. How about our own? We are waiting for what? People say that, look, let's wait first. I still don't have money to trademark. I'm looking for money and then let's market it first. Assuming we market it and then someone takes the trademark, what happens? In a dispute. Those are things now we need to look at. It's good I'm talking to managers so I can emphasize that when it comes to trademark and brand building, trademark first and build the brand, not the other way around. Get a trademark so you build what is yours. Don't build what you can be able to, what you're likely to lose. This being just data for trademarks. If I brought data for patents, you'll be surprised. Even Kenya alone, people don't patent. So when you have intellectual property, the rights that you accrue, that you get as a result of having them, and they call intellectual property rights, they're legal rights that provide you as the original creator or inventor, that provides you some protection so that nobody can be able to use your work without your, to use or distribute your work without your permission. So again, when you talk about intellectual property rights, remember there's some rights that you get automatically when the property has been created, like for copyrights. The moment you sing and you get the name, the song recorded, you have automatic rights to that song. Copyright is assumed automatically. Patent is not assumed automatically. Trademark may not. So you have to know how to get these rights. Your databases, even with the ones that belong to industrial secrets, there are things you do and you lose the rights to them if you don't protect them, that is. Intellectual property rights infringement refers to any violation or breach of protected intellectual property rights. Violation or breach. Your rights may be infringed upon in many ways. If someone copies what you have, if someone distributes what's your intellectual property without your authority, reproduces, piracy is part of it, counterfeiting is part of intellectual property rights infringement. When your rights are infringed, the law protects them in two ways because we have aspects of which is the criminal and part of it of civil offense. The difference is that, like for example, counterfeits, you can be arrested and fined by the government for counterfeiting some products. but the owner of that particular product has been counterfeited can also sue you and claim damages. So that's actually what it means at this level. So what is IP assets in terms of how you look at it as a manager? It's either a resource or a risk, they call risk center, or where the risk is likely to come from. So as a resource, intellectual property can be identified, can be transferred, and have economic lifespan. That's why it's called intellectual property assets. We can say, this is it. We have these patents. This process has been patented. And we can actually sell the patent to somebody else. We can list it out. Over some time, that patent's lifespan will be depleted, I would say that. Maybe I didn't mention earlier on that while copyrights protects your rights to that creativity in your lifetime plus 50 more years. Patents only protect your right to it for 20 years. It can be extended by commonly around 5 years maximum, but for 20 years. So when you patent something, you have exclusive rights to it for 20 years. You may apply for extension of that. Because granting of the copy of a patent also takes a long time. It takes up to 5 years for you to get a patent granted, as compared to trademark, which takes about 7 or 3 months. Copyright, within a week, you have protection register, certificates. If it goes to industrial designs, that should be about 10 years, non-renewable. But there's annuity for industrial design and annuity for patents. That when you protect your patents, every year you should be paying some amount, and it's calculated, a formula of calculation of the annuities. So if you don't pay that, again, you lose the patent protection. Those are things you have to be careful about when you're looking at your IP. Although these intellectual property assets are intangible, and sometimes difficult even to explain to somebody that you actually have these as assets, they can be more valuable than physical assets. Okay? Remember the case of the one you just showed there about the please call me. It's so easy to have the value of that please call me, the idea, having higher value than many intangible assets put together. Or think of the case of that photo of Salt Bay. I think if you look at the paints and all that, it can be much, something that should not be costing about $5 million. So you see that IP aspect of it is more expensive. So next time you're dealing with the websites, you may be surprised if you get a designer who knows IP. They will tell you, I'm selling to your website at 20K, but when you want the IP, 1 million. Don't be surprised. There's something called IP evaluation. They can go to do evaluation of the IP and tell you how much it costs. It could be more expensive than having the websites. And what you say that is the IP presents competitive advantage to your corporation or to your company. That's why many people know that actually it's the business. Why do people come to buy your product? Is because the brand or the trademark that protected? Is this because of the patent or the process you're using that make it, if it's something that probably is yogurt, tastier, So it gives you an edge over the rest. And the good thing about it, legal protection also precludes others from coming into your territory. That means you can be able to make so much profit out of it for a very long time before the patent expires, for example. And if someone wants to use it and they decide to license it or to lease it out, then you still be getting money. See that? So it gives you competitive advantage and also a resource in that perspective. So the resource perspective of IP, one, IP gives you a strong market position and competitive advantage, that's clear. A well-protected brand, well-protected processes and the products in terms of patents and all that will always keep you ahead of the rest, because before they come up with the same solution that you have, they may need to invest a lot in R&D. They need to invest a lot in even prototyping and all that. But remember, they'll do all that as long as they don't copy yours. If it is protected as a patent, it gives you higher profits and returns. If at all you are going to use your money to do research on this, how do you justify the amount of money that you spend on doing research to come up with better processes and better products? It's by registration of the outcome of that. And I remind you, if at all you're doing R&D that's likely to lead to a patent, as soon as that comes to your mind, contact IP experts. Because if you do it wrongly, you'll end up with a product that cannot be patented. I've seen some of our clients telling that I want to patent, but I've already discussed with Mr. XYZ to see whether he can be able to distribute the product on our behalf. We gave him a sample, and what that makes your patent not protectable. So some small mistakes you're going to make are likely to render your patent not protectable. It can give you additional income, as I said, like licensing or selling or assigning. IPs give you bargaining power when assuming that you want to get out of business, and therefore what you want to do, you want to sell it to somebody else. Probably they'll ask you, what do you have? We have this building, we have this, you have this, plus patent registered in Kenya and the UK, or in the US, or in Germany, and you know that increases the value of your bargain. It enhances the ability to acquire financial assets. Remember, it actually can be collateral, used as collateral. It gives you a strength or credibility to threaten or take action against someone infringing your freedom or your rights on it, or imitators or free riders. And of course, it gives you a positive image. A company that does protection for IP looks more serious than the ones that are just trying things out here and there. Of course, in our observation, small organizations that go through IP protection, like trademarking and patenting, once it goes through, they look a bit serious and different. The way they regard a business becomes totally different. That's our observation. They become more serious with it. I think because of that feeling of ownership and some assurance that this is mine, you work different from the way you would have done if you're just saying that, let me get my products out in the market there, and then you see, if it picks, then you can go and trademark it. There's that feeling, I think, that comes with the registration of your IP that makes you look serious and makes you feel serious. And of course, for me, that is actually an advantage. On the risk perspective, remember we said that it's good for you to look at your IP as an asset so they can be able to increase your value as a corporation. Now, as a manager, what are things you need to know again on the side, the flip side? Assuming you don't really care whether you own that IP or anything like that. Remember, you're dealing with many IPs, some are not yours. So there's a possibility of infringement of some other company's IP, including suppliers, okay? Including companies you don't know. Even new entrants can still be able to come without knowing that you do exist because you're not registered, you don't have a trademark. They come and register their trademark, they start trading along the way. You realize next thing, you're seeing a letter of cease and desist. Stop using that name, it belongs to us. What do you do? So if you don't register it, there are chances of infringement of other people's IP. So there's a risk about infringing others. You may not mind your products or your IP being infringed, but if you infringe the other guys, remember what will happen? You'll be able to be liable for that. And there's a weak position in protection of your IP, your own IP. If you don't look at your IP from a risk perspective, you're likely to have IPs that you're using on a daily basis are not protected, and that gives you a weak position on when you are probably have a dispute with with your competitors. So there's a risk on that. There's also a risk of conflicts with your employees. What if your employees are the ones created that product or maybe that patent? Would you go and patent it and leave him out? The law is clear on that. I'll not get into that for today because that's a technical aspect. But remember, you need to think about the possibility of conflict between the employee and employer, or the someone in your department claiming that, yes, I've been sacked from this organization, I want to go with my IP. This is my creation, and I have proof that I'm the one who came up with this particular process or product. So that is a risk perspective, a risk area. There's a possibility of conflict with your partners. When you sit on the table negotiating many things, you want to work together and come up with maybe R&D on how to improve some process. Then along the way, you fall apart, you happen to have a dispute. If you didn't think about your IP, as asset, the dispute is likely to escalate and become even something that you may not manage. So there's what things you need to do when you're engaging other people and IP is involved. I'll mention about that later on. There's also possibility of loss of value due to dormancy. You have an IP, you don't know anything about it. You probably have not protected it. You probably have not commercialized it. Along the way, it's not giving anything. It's not helping with anything. It's dormant. It's a resource that's lying idle. Unlike land, physical land, IP only makes sense when you commercialize it, by the way. Otherwise, it's useless. Then you can also lose value of IP due to non-renewal, like lateness, there's a charge for lateness, or sometimes you lose the value of that particular IP. That's the risk associated with IP. All these things translate to there's some financial impact on it. And there's loss of value associated with dilution on and protection. Assuming you have a trademark, which is already registered, someone is infringing, you don't know, or you know, but you think, let's give it some time. After some time, your product means nothing distinctive in the market. It's dilution. Okay? And sometimes reaches a moment where your trademark. I should give example of escalator. I think escalator was a trademark, which got diluted, and now it has no distinction. It has no distinctive effects in the market, so you can't use it as a trademark anymore. What do we have to do in the process of management of IP? The things that you should make normal in your organization. Urgently and very importantly, you should have IP policy. You should have a policy that shows how IPs of others, your own IPs created by employees, are actually dealt with in the organization. And this has to be communicated very well through trainings and sensitization to all staff. Reason being, remember, if your staff infringes other people's IP, you have vicarious liability. So you need to have an IP policy that shows what can you do with your own IPs. Do you have trade secrets? How are they supposed to be handled? Who is supposed to take care of them and all that? So you need to have IP policy as part of the IP management. You need to carry out IP audits so that you can see what IPs do you have within, what's the status in terms of protection, what are the risks associated with them, and all that. You need to maintain your IP register to avoid dormancy, and to also schedule commercialization of an IP in terms of priority. This one goes fast, this one has more value than the other one, because you can't spend on all your IPs, by the way. You can't protect all of them, and you cannot commercialize all of them. So you need to have a register. You need to maintain IP register also to ensure renewals are done on time. Less renewals can be costly in terms of it can be surcharged, and you can also lose the IP if you don't renew them. Commonly, after registering, say, trademark, the next time you are going to renew your trademark is 10 years from then. Probably if you are the CEO or the manager, you won't be there. The next person will come may not know where that's the trademark registered or not. If they don't renew, what happens? They lose that value. So they should be clear that what we have, when we're supposed to renew, if it's a trademark. If you have a patent every year, when are we supposed to renew without any surcharge and all that? Very important, should carry out IP watch and surveillance. This is what is lacking in most developing countries. We think that once you've gotten a trademark, all is well. Yes, someone can be found counterfeiting your products, and there's a way it's dealt with, and know how our systems work. They can still get away with it. But you have responsibility of ensuring that your IP rights are not infringed upon. The question I'll be asking is, how do you know whether your IP is being infringed on or not? How would you know that your patent is being infringed on out there? Remember, your work 8 to 5 is well cut out, and one of the things you may not be doing is watching over the IP, the surveillance, to ensure that's not being infringed. There's a case that I think is still live between Apple and Apple in the US, where Apple has sued Apple for infringing their trademark rights, the rights on trademark, or the trademarks. If you look at it through the perspective or the eyes of a layperson, you will not be able to see how they are similar in any way. But if you engage an expert in the area, they'll tell you that there is an infringement here. Sometimes you'll think there's infringement and there's not, while sometimes you'll think there's not and there's an infringement. Without any responsibility on this, I remember the case of Absa versus Absa in Kenya, where I think there was an Absa in Kenya, and I think they sued the Absa that was coming to Kenya. And I don't know why someone even went to represent them, because they're not in the same class. There was no infringement. The Absa in Kenya was a different class from the Absa that was coming as a bank. I think so. I'm not so sure about the details, but I remember something of the sort. So when is your product or your IP being infringed? You may not know, but engage IP surveillance services. They're available. Thinkly IP does it, and of course, I think many other companies could be doing the same. Get your documentations right. I think we know the story people have talked about. I don't know, in M-Pesa, someone came with this, they went and described this to somebody, and somebody disappeared with it. It's a common story every day in Kenya, and we keep crying after that. Why don't you just get an expert from the onset? If you think you have an IP, you want to have a negotiation with a partner, or get the documentations right. There's non-disclosure agreements, transfer of IPs, and all those documentations are done by experts. Thinkly IP will do them. I know some other people also do the same documentations. And a good example is when you have a website, and in your thinking is that you bought the website so you can do anything on it, yet you didn't have a transfer of IP clause in your engagement with the web designer. All that can be exposed at IP audit. When someone does IP audit for you, they're able to check your documentations, your agreements, and tell you that here, you've been doing this, you think you have this, it's not yours. This one you think you don't have is actually yours. So that can be exposed. So get your documentations right everywhere at every step, so you don't lose your IP. Commercialize your IP, make money out of it. Make money out of your IP, whether it is through licensing, whether it's through assignment, whether it's through any way, make money out of it. Others doesn't make out of value for you to have IP, you're not commercialized. These all can be given to you by your consultant. So basically, in short, on IP management practices, I recommend that you get IP experts so that you can get your IP policy properly done, IP audit properly done, IP registration done. It's not about filling forms. Remember, when you're doing, for example, a trademark belongs to a class. There are about 45 classes. Which class are we protected yours against? The case of Absa versus Absa, I think, was the issue of class. So you think that you're in the right class, you feel that you have a certificate, but are you protected that certificate? You may not know. Don't just go and fill forms trying to reduce the cost. And then at the end of the day, you have a certificate that does not save you when you're in trouble, when there's a dispute. So get experts at every stage and get things streamlined. That's why we call it management. Streamline your IP management, align it to your strategy, and remember, you have to find a way of making money out of these while they're still viable. Before this, just one more thing I'll mention here. Let me say at this level, there's something called IP disputes. I did not put it in my slides, but it's good for me to mention that when you find yourself in disputes of IP, what do you do? When you find someone infringing at IP, your trademark, for example, what do you do? Not all IP disputes should go to courts. There's still negotiation, there is mediation, and there's arbitration. think of the story about Shakira. In Shakira, they said they did what? Out of court settlement. I'm sure if you go online right now and find out how much she paid for that, you may not find it. Because if it was through arbitration is actually, what do they call it? It's confidential process. Those are quasi-legal in the sense that it's the same way a judgment may be rendered, pseudo an award. But the thing is that the parties have control of what gets out there. So it cannot mess up the name of the person involved in arbitration or mediation or negotiation. But you can still go to court. That's still allowed. Of course, courts there to serve your interests and be able to adjudicate your disputes. Of course, before you even got all that, there's a letter that's sent. Get your IP consultant, tell you what to do before you start making blunders in the process. Thank you very much. Any questions after this, you can still forward them. I have my email there and my phone number. A bit about Thinkly IP, what you actually do, if you allow me, Tom. I just quickly mentioned that Thinkly IP does copyright registration and consultancy. We do patent registration and maintenance, utility models. We do all the training and consultancy, audits and management, and also we do dispute resolution IP. When Mildred was introducing me, she asked me to say what those memberships mean. International Trademark Association is an organization that deals with the actual promotes trademarks, and a very old organization from 1870 something. It's US based, but it's global. So it promotes registration and protection of trademarks globally. There's an arm of it called ADR, and we try to see how this resolve disputes based on IP through alternative dispute solution, because sometimes the disputes can be cross borders. Lastly, I'll just mention that you have to remember that IP is actually territorial. Your registration of trademark in Kenya does not guarantee your protection in Uganda, for example. Of course, the system of registration that are global in nature, like Madrid system, can allow you to cheaply or in a cheaper way register your trademark in so many countries by one application. We have the RIPO system, which is Africa, and the other ways of dealing about it. But just remember, they're actually territorial. Thank you very much. I invite any questions. Thank you.
Thank you very much. Thank you very much, Mr. Nyagare, for that very powerful presentation. I think members here who have logged in have really seen and benefited from the value of this presentation. That we thought we knew about intellectual property, rights or services, but I think we just had like a tip of the iceberg. Thank you for sharing with us that great knowledge. I like the way you actually brought out the idea of a need to ensure that you align your IP policy with your strategic trust, because then it becomes easier to implement, and therefore you can be able to narrow it down to specific performance indicators in terms of ensuring that you are safe as an organization. And also the way you shared with us the best practices in IP management. I think those are good points, how you can even come up with IP policy and need to do IP audit and all that. Some of these things, I think we didn't know that they are also very necessary. We thought it's just a matter of registering, but I think it's also important the way you shared with us that there's a need to have IP surveillance, very, very important. So these are very good points. Thank you, Tom, for sharing that with us. And I think members will be reaching out either through KM, of course. There could be other areas of working together, just in case there's a need to have IP expert on board. They want to do the surveillance, they want to do the IP audits, they want to develop IP policy. I think we should think IP and Thinkly IP as it is, as the name of the organization goes. So thank you very much. We appreciate that. There are quite a number of questions that came through. Mr. Nyagare, if you could just grab your glass of water, if you're ready, let me know, so that I can shoot some questions here that we received from the members. Some of them have been posted on the chat box, but if you are ready to go, there are like 3 questions that have come from Dr. Peter Kitonyo. And Dr. Peter, the first question that he's asking, if you could note that down somewhere, some academic journals request that an author completes a copyright form, right? Some academic journals request that an author completes a copyright form to consent to have the journal published, as in to have the journal publish the academic works. The question is, what does this act mean to the author? What does this act mean to the author? The second question from same Dr. Kitonyo. We have cases where employees come up with an invention or innovation that helps the employer conduct his or her business better. What are the rights of the innovator employee? We have cases where employees come up with an invention or innovation that helps the employer conduct his or her business better. The question is, what are the rights of the innovator employee? Attached to that also, there's a second question. What does the law and regulations provide for such cases? What does the law and regulations provide for such cases? And last question from Dr. Kitonyo on the same subject. The IP registrations in Africa are fairly low compared to North America and Europe. Why is it that so? Why is it that so? How does Kenya compare with the rest of African countries? So those are the first 3 questions. Tom, if you could please address them. These are questions that have come from Dr. Kitonyo. And as we continue, if you get other questions on the way, we shall be able to share them with you so that you can be able to address them. Dear members, just in case you may not address all the questions this afternoon, we will share your questions with the speaker and of course share the details, the answers and all that with you later on as we send you the presentations. As I said earlier on, and I've seen questions coming through, yes, we'll share this presentation with paid up members, care members. And so if you're not a care member, we encourage you to validate your membership, register as a new member, or if you're an active member, please just ensure that you validate your 2021 membership status. Thank you very much. So Mr. Nyagare, do you want to take the first 3 questions, please? Thank you very much.
Thank you very much, Tom and Dr. On the question about academic journals. Usually say the devil is in the details. What's in that form that you're filling? That's the most important thing. You can fill anything. Sometimes you may have a form that actually leads you to transferring the intellectual property, that copyright, to the publisher. It is possible. If I saw one, I'd know what actually they're trying to say. But the form could also be used to give authority to the publisher to distribute your work without you necessarily losing your IP. So you need to know exactly what's that form. Anything you realize that it's possible actually to give your IP by consent. So you must be very careful what you're signing in that form. But I think fairly it could be just give them authority to distribute, because distribution of your work without your authority is an infringement, and that's a risk they will not want to take. But some of them may go ahead and tell you that, see, sign these, and if you don't read the details, you find that actually you've transferred everything, your rights to them, at some consideration that may be minimal, and you not even knowing it, can only be found during a dispute resolution, maybe in court or by arbitrator. On the issue of employees who are innovative, first thing I'll say, think of the policy. Your policy overrides many things, because you find an organization where it's been agreed upon, and there's a policy that if you come up with something new, then you're going to be rewarded in some proportions, what percentage and like that. I think that would also be very important, where to encourage employees to innovate. However, whether to tell if the employee is entitled 100% or by proportion to the work that's been created, there is an employee who has come up with an IP as part of his work that is considered. Was it part of his work or was it something extra? Assuming you employed as a marketing manager, but the process you came up with a way or probably of automation or something like that of your diaries and stuff like that, which may need to be adopted as an IP within the organization. Is it part of what you expected to do or is it something extra? If it's extra, of course, know how the law is going to lean, because remember the law is protecting your IP as an individual. It's a private right. So that's something you may need to look at, but sometimes you can just go ahead and have it in the policies and the employment contracts, what happens to the IPs, so that you can have proper assignment to IP that has been created during the work relations. On the issue of registration, the law registration in Africa, I think number one, which could be very unfortunate, is that most IP offices in Africa are not efficient. They are not efficient. And you may call some of them and ask them, when do I expect my trademark to be registered? When do I expect my patent to be? And the person who picks the call does not know, or give you a date that cannot be determined, you know? Like maybe next year, maybe next week, maybe see this kind. So that efficiency is a problem. And that discourages most people who are getting into business because you want your things done so fast and you roll out your business. So first of all, the efficiency of these particular IP offices. Another thing is awareness. There needs to be deliberate awareness at many levels. Dr. If you're teaching in the university, I think we need to have your students to also understand what IP is all about, so that the moment they get employed, they know what it means as a manager or maybe as an employee, that this innovation should be protected, this was assumed, this and that, so that people can be aware. And if you protect, how do you protect them? So awareness is a problem, but awareness, the IP offices, the government should be deliberate on that. Of course, the school or the universities should be deliberate on making awareness on IP. So awareness is a very big problem. And of course, if you go to some countries like China, for example, they make applications in thousands, hundreds of thousands at once, or even America, things have been automated. So laxity or the technological challenges probably could also be causing these law registration. But I also think that generally in Africa, people don't respect experts. You know that most of us here are actual experts. People don't respect experts. They prefer to do things in a shortcut way. So that could be a serious thing, so that you find someone just, how much are you going to charge me to do A, B, and C? Oh, just filling a form. They go and fill the form, and along the way, they realize the process is frustrating because you have what you call official action, you can't respond to it. Okay, so that could also be a problem. I think I've answered the 3 questions. Tom?
Thank you, Mr. Nyagare. The other questions that are trickling through now, if you look at the chat box, let me just pick them. There's a question that has come through from Wilfred Maina. How important is registration of copyright? I think you captured that in your presentation. Are there any cases of infringement, particularly for literary works in Kenya that have been successfully prosecuted and damages paid to the author? Probably that is also tied to the question that Dr. Kitonyo asked. And then there's a question from Jocelyn Corie, who is asking, what is your advice concerning innovations or works of art created by children who are below 18 years? What is your advice concerning innovations or works created by children who are below 18 years? That's the second question that has come through. Then, of course, we have the Gabriel Okumu is asking you, please, at some point, you share your address once again, the clip that, the slide that had your address, so that they can reach out to you. Sorry, let me just check. Down there, the last question on that, we have many innovators who do not have financial muscle to register and even commercialize their IP. What do you advise on what they can do? That is also from the same Dr. Peter Kitonyo. And then lastly, last but not least, as I said, members, if you may not address all the questions because of time, please. The last question there is, can we call IP intellectual capital, or what is the difference? Can we call IP intellectual capital? I guess that now will be IC. Is there a difference? So that's the last set of questions. Mr. Nyagare, if you just address them, we'll appreciate. Thank you very much.
Thank you very much. These are some of them are very challenging. Registration of copyrights, it's essential. As I mentioned, that you assume copyrights as soon as you create your product. If it's a song, as soon as you sing it, remember, for you to register it, you have to, there's something called fixation. It has to be a recorded form. The copyright works have to be recorded forms. So it can be maybe the notes on a paper, it can be recorded as a video and audio and all that. So the important thing about registration of copyrights is that it gives you advantage when there's a dispute, because that's an evidence of ownership. Unlike trademarks go through a lot of examinations before you get your trademark registered. Copyrights may not go through a lot of those a lot of those examinations. They just meet some basic threshold and get them registered. But it's essential, it's good because it's actually evidence that you own it, so that when there's a dispute, you don't have to have trouble in trying to prove your ownership of the same. Of course, there are many cases of copyrights. I don't have any that come into my mind very quickly, but I know just recently there was, must have been last year but one, when someone was distributing copies of Nation newspaper. I think you must have seen that. Someone in Mombasa, I think so, and he was arrested. That actually was a copyright infringement, because there's no, whatever, I don't know how far it went, but that was an infringement. So that's one of the cases I could think of very quickly. Jocelyn, for children who are minors, who are creatives, I don't think there's a preclusion. You're not precluded from creativity if you're a minor. Of course, you probably may be looking at someone like, was it called Michael Jackson, who started making a lot of his copyrights when he was still very young. And we have so many of the people who have made the copyrights. They still have ownership. The only thing is that they may not be able to transact in the ownership directly, but they have the ownership of those particular IPs that they create. You can't snatch them from them. It's their right to have them. I just want to emphasize, Jocelyn, that particularly with copyrights, there are usually two types of rights. One's called economic rights, and there's a category called moral rights. Economic rights are the right to earn out of your copyright. Moral rights are the rights to be identified with your work. You cannot take away the moral rights. They are not assignable. You can sell your economic rights, but you cannot be able to sell your moral rights. So that's very important when it comes to issues of children. Mr. Kumu, I think my address is there, but I think again we'll be able to share these slides, so you can be able to reach us when you need more, when you have more questions. Innovators who have no muscle to register. That's a very tricky question, because if you're buying land, remember IP is actually a property. How can you buy land without money? You have to registration. You need to have what you call title deeds. You have to have some money. You have to get, ideally, and some people have done this. Some people can, if you know that this thing is a good thing, you can borrow money. You can borrow money to registration. By the way, registration of IP in Kenya is comparatively cheaper. And I wouldn't want to say this loudly, so I don't know how low my voice is, but the way we look at IP registration in Kenya, Think Like IP, we try to address the SMEs and the economic muscle aspect, because we know that if we go strictly in terms of, we're professionals, how do like this, many people that you want to protect will not be protected. So it depends also on your negotiation, because you have usually 3 types of fees when you're getting someone to do for you IP registration. There will be government fees, there will be tax, and of course, service fees. now you can negotiate the service fees. Have I given you an idea? Yes, if you don't have sufficient, because government fees, there's no way you can register for free. You have to pay. Tax you have to pay. But then the person who's listening for you, discuss with that person and say, can we talk about this and negotiate? I've seen that's a global practice, because whenever we get requests from India, from Malaysia, and other countries, you still find the advocate there asking that, can you do for us a good deal because you expect to register so many IPs with you? You see, there's a negotiation aspect in IP, and that's a common thing. And whether to call IP intellectual property as intellectual capital, that I would say, and honestly, I'm not so sure what intellectual capital, what other meaning it would have. But I think from the face value, I don't think there's any harm. You know, you can call it anything as long as you know what it is. And as long as now you take advantage of it for the success of your business and your stuff. Thank you.
Great, thank you. Thank you so much, Tom, for well-articulated answers. We really, really appreciate. Even looking at the comments on the chat box, members have really appreciated your presentation. And again, we thank you all members for your time. Looking at the fact that we are closing with still 47 connected, it's a great thing considering that today is the budget reading afternoon. So to come and spend your time on this webinar, it just shows the level of appreciation you have and your support for the Kenya Institute of Management that we really don't want to take for granted. So thank you so much. We look forward to the next webinar that should be coming up in the next 2 weeks, 24th of June, and we'll be able to share with you details of that webinar well in advance so that you can internalize the topic and also share with us your questions well in advance so that the speaker can address them. So thank you very much, members. I want to hand it over back to Mildred for closing remarks. But again, before Mildred comes on board, members, this is your forum, it's your webinar. Please reach out to us in case you have any subjects that you want us to address. Just share that with us so that we can get you, the appropriate speaker, to do that. It's part of our capacity building to you as members as we do this after every 2 weeks. And we expect you to, get better as we move forward to the next level where we'll be having this kind of engagement. So thank you very much. We appreciate. In case you want to reach out to Mr. Nyagari in terms of IP management, we'll share the presentation with the paid up members of 2021. And of course, in that, you'll also get his contact. And again, we'll still have other opportunities. You can still reach out to Ken because this is a partnership between Kenya Institute of Management and ThinkClear IP so that we can work together and ensure that whatever business that we are doing is a business that is protected within the legal confines. So thank you very much. Over to you, Mildred.
All right. As we come to the tail end of our webinar, I wish to register our vote of thanks. And I want to start by saying that, just a quote, that the only people whom you should be getting even with are those who have helped you. It's a quote I've borrowed from John Southard. So at this point, I want to get even with you by thanking you members very much for attending. Just as Tom has said, it's a very busy afternoon. It's a very unique afternoon. We all want to know what's happening to our economy, which will impact on how we'll implement our intellectual property. So for you to sit through this session, thank you very much. For the council members who joined us, I saw Rose, though she left at some point, but it is very inspiring when we sit with our leaders to see how we are executing our duties and also share with us their knowledge or share with us sessions that we have arranged. This is very exciting. It's very inspiring. For Kim's staff, for organizing this, of course, I cannot say, oh, you're here. Oh, sorry, Rose.
I'm there.
Thank you very much for joining us this afternoon. For Kim's staff,
I'm also there.
George Muyera, thank you very much. Anyone else? You see, they walk with us, and that is very motivating and very inspiring. Kim staff, thank you for organizing this, especially the membership and communication team led by Tom. Tom, a good job done. Please keep it up. Let's have more of them coming. ICT team for keeping us clean throughout and engaged. Thank you. And last but not least, our speaker for this afternoon. Your session, Tom Nyangare, has been very insightful. Just comments, some of the comments we have got from the from the attendees. Eye-opener, great presentation, very good. So that means it has been intense, it's been very insightful and full of knowledge. And thank you very much for sharing. That is what Kim is all about. Learning, sharing, and sitting together to see how will we implement this and make our organizations better. So thank you very much. And on that note, I want to invite all of you members, just as Tom has said, please renew your membership so that you may get recordings of this particular webinar, not just this, but many others, including our management magazine, which has information, more information about topics like this. And also, I'm inviting you to sample many more of our products, certificates, diplomas, conferences that are coming up. Other than that, Tom Nyangare, we look forward to seeing you again, maybe in another forum. Definitely we have to have another forum. And for the members, I'm looking forward to seeing you not only in the next webinar, but also in our other forums and other activities. So thank you very much. At this point, I will want to release you and say a good afternoon. Let's internalize what we have been shared with. Let us go practice and let us share, and let's invite many more people to come and hear what we are doing. Asanteni sana. So on that note, I think, Tom, we are good to go.